Alright guys, welcome back to another edition of Lawyered Up. I am your host Jared Moore, and for the record, I am not a lawyer. On today's program, I'm just going to be talking about the final order in the Grayson Kennedy case that was issued by the Supreme Court. There's a link to that order in the description of this video. I wanted to go through it just because they're basically closing the case, and also it kind of addresses some critiques that citizens and other, like the legislature and stuff, have had of their orders and stuff. So like I said, there's a link to in the description here, but I'm also going to show you guys how to navigate to the case just like we normally do. So without further ado, let me pop that up. This is the Supreme Court's website here. I'm going to go to Final Opinions. I'm going to scroll down here to, as you guys know, well, I don't know why. Okay. Sorry, my computer went wonky there for a second. Let's look at here's the case. At the bottom, you will see that there is now the order denying respondents' motions for contempt, denying respondents' motions for temporary restraining order. So let's take a look here, guys. I'll keep that out. So before we get into the order, I wanted to point out here, you can see that Harjo Ware and MC McNack recused and not participating in the decision. Stromsky not participating in decision pursuant to Administrative Order 2025-05. So let me explain that a little bit. I had to dig into it a little bit. If we go on the Supreme Court's website to justices, you will see here's the justices that are listed, and then there's Justice Jessica J. Stromsky. Okay, so Stromsky is not participating in this order. To find these administrative orders, these are basically orders that the court issues about its own operation, its administration, and you can find those normally here on the news page for the Supreme Court, and it says, you see here there's Administrative Order 2023-05, Administrative Order 25-06, and 26-03, but they don't have posted on here 2025-05, which is the administrative order mentioned right here, as you can see, guys. So I don't know the reason why Stromsky's not able to participate in this, because I haven't read this administrative order because it's not on the website. I just wanted to call you guys' attention to that. It's not a big deal because Stromsky wasn't on the court when this case was heard. The oral arguments were heard anyway, so not big issue there. So I'm going to read through this whole thing, guys, just because it explains why they're not granting these motions for contempt, and also it gives a little of their what the Supreme Court wants to say to citizens. So let's jump right in here. This matter comes before the court pursuant to the respondent's October 14th, 2025 renewed motion for contempt and for court enforcement of order and judgment and for order to show cause, and 2, the respondent's March 9th, 2026 third motion for contempt for court enforcement of order and judgment and for order to show cause, and 3, the respondent's March 9th, 2026 motion for temporary restraining order and preliminary injunction. For the reasons stated below, the court denies respondent's petition or pending motions and closes the above-styled case. This action was initially brought by the Citizenship Board of the Mvskoke Creek Nation via its September 29, 2023 Notice of Intent to Appeal and filed pursuant to Rule 2 of this court's Appellate Rules of Procedure. The purpose of this appeal was for the court to review the September 27, 2023 decision of the Mvskoke Creek Nation District Court and its interpretation of certain treaty rights and constitutional rights concerning citizenship and their impact on certain freedmen applicants seeking citizenship within the Mvskoke Creek Nation. This action was properly filed with the lower court and later with this court and included the necessary parties to resolve the dispute. In the course of this appellate action, the Mvskoke Creek Nation National Council petitioned the court for permission to intervene for purposes of submitting an amicus brief to the court. This request was denied, and the National Council did not participate in the appeal in any capacity. Following the filing of this court's order and opinion on July 23, 2025, the respondents have sought enforcement of the court's decision against the executive branch and the appellate board. That's the citizenship board. In response, this court has issued 2 requests for status reports from the appellate and the executive branch generally. The evidence produced to the court in response to these orders for status reports has shown conclusively that the appellate and the executive branch have taken steps to comply with this court's order and opinion, though perhaps not in the manner at the speed desired by the respondents and, to be frank, not at the speed this court would prefer. However, the court finds that the respondents' pending motions should be denied. Now they're going to explain why they're denying the motions. First, the court is keenly aware that the legislative branch of this nation's government is not a party to the above-styled action, and further that this court has previously denied the National Council's request to participate in a limited capacity in this case. As a result, the legislative branch was not a party to this case, and the court's prior orders did not and could not impose obligations on it. This highlights the primary deficiency in the respondents' attempts at enforcement through this already open action instead of beginning a new enforcement case with all necessary parties. The same is true with respect to the respondent's motion for temporary restraining order and preliminary injunction in an action in which the legislative branch that passed NCA 26-061 and the election board administering the May 2026 special election are both not parties to this case. Simply put, the proper parties necessary to achieve the respondent's requested relief are not part of this case. Okay, so there you guys can see that the court is just pointing out that they can't order people to do stuff that's not part of this particular case. Finally, this court has consistently followed the traditional rules of justiciability. Following this approach, only justiciable matters may be properly adjudicated by our nation's courts. This court is obligated to review justiciability as a threshold issue and dismiss claims that are determined to be non-justiciable. This includes political questions committed to the legislative and/or executive branch of the government. As mentioned above, at the outset of the above-styled action, this court was presented with a justiciable question concerning the interpretation of the Mvskoke Creek Nation Constitution and the Treaty of 1866. However, the respondents' post-order motions for contempt present a new issue entirely, enforcement, and would have this court insert its own judgment concerning the manner of completion, timing, and legislative language, among other things, over that of the political branches of the nation's government. This would be in violation of the court's judicially imposed criteria concerning political questions. This court has issued its order and opinion and has resolved the only justiciable dispute presented by the appellant on appeal. That decision was subject to further scrutiny by this court through the Appellate Rule 24's petition for rehearing process and was resolved again in favor of the respondents and is now final. Judgments concerning necessary legislation to implement the court's decision, commissions that may be necessary to prepare for expected changes resulting from the sudden influx of new citizens, and how much time is necessary to responsibly implement these changes are political questions that must be left to the branches of government assigned those tasks under the nation's Constitution. Okay, let me take a look at the chat here real quick, guys, just to make sure I'm not missing anything here. Let's lace up to illegal hunting and fishing rights. I'll look into that in just a minute, TY. Let me go back to what I'm doing. The next part that I'm going to read is kind of like the court. Is the part that I really wanted to read to you guys. Let's take a look at it. As dicta, the court would also share the following to the parties and the nation as a whole. So this is why I wanted to read this to you guys, is because this is the court is basically addressing you and I as citizens. One of the unique features of our nation's judicial branch is that our Constitution authorizes the appointment of non-attorney, traditional Mvskoke experts to seats on the Supreme Court. Currently, 2 of the 7 seats on this court are filled with traditional experts. It is no exaggeration to say that in every case filed with the Supreme Court, these traditional experts provide insights that book and paper law simply would not afford. Our nation is benefited tremendously by this unique approach to appellate law. In the above-styled case, our court has attempted to honor both traditional legal concepts, analyzing our statutory and case law precedent, while also honoring Mvskoke history and tradition. At the forefront of our analysis in this case has been a deep consideration of the past. In the time leading up to the signing of the Treaty of 1866, it would be fair to say that many of our ancestors would have been dismayed at the retributive nature of the Treaty of 1866 and at the prospect of entering into such treaty terms. However, they did so. They did so with the fervent hope that such a course would secure a better future for their prosperity. From our vantage point today, we see that their decisions, their efforts, and their sacrifice produced their intended results. The Mvskoke Creek Nation stands as a sovereign entity and is stronger today because of our ancestors' decisions, with our nation's sovereignty resting in large part on that same Treaty of 1866. It would be both a disrespect for our court to reject this history and, perhaps more importantly, a danger to our nation's sovereignty to expect that certain advantageous terms of the treaty should be enforced, while certain terms that some may feel are disadvantageous should be ignored. It is clear to this court that, like our ancestors, many among our citizens today are also dismayed at the prospect of this court's order and opinion, and would have preferred that the court had ruled differently. Also, like our ancestors, this court's fervent hope in this case, and in every case that finds its way to our docket, is that our decision will secure a better future for our nation and make clear to all that the judicial branch of the Mvskoke Creek Nation produces just results to all parties, honoring both our tradition and our legal precedent, even if some results may be hard. 5 values inherited from our ancestors and elders anchor Esta Mvskoke, the Mvskoke people, and they anchor this court as well. And I apologize, guys, if I mispronounce these Mvskoke words. Athlakquekucha, respect, calls upon us to honor the rights and dignity of every person who comes before our bench, and to honor the promises our nation has made, including those memorialized in the Treaty of 1866. Fachechida, integrity, and Mvskoke, responsibility, call upon us to be fair, honest, and accountable in every decision we render, loyal to the Mvskoke Constitution and laws we have sworn to uphold, and diligent in the work of judging without regard to the prevailing political winds. Yaskida, humility, and Obothinka, wisdom, call upon us to remember that the court is one branch among 3 co-equals, to be mindful of the well-being of the nation we serve, and to draw from both scholarly learning and from the knowledge and experience of our elders, whose decisions, made under conditions far harder than ours, resulted in the treaty-defined permanent homeland we enjoy today and that still shape every aspect of our nation. These values guided the court's analysis in this case, and they will guide every case that comes before us. The justices of this The justices of this court take their oath seriously and decide each matter before them without fear or favor, affection or ill will. In a government composed of 3 co-equal branches, disagreement among the branches is not only permissible, it is to be expected. Each branch is charged by the Constitution with a distinct role, and the friction that arises when those roles intersect is itself part of the constitutional design. This court's responsibility is not to avoid that friction, but to discharge its own duty faithfully when called upon to do so. We lay this order and opinion at the doorstep of the political branches of government in the hope that they do the same. It is hereby ordered that the respondents' October 14th, 2025 renewed motion for contempt, etc., and March 9th, third motion for contempt, and March 9th, 2026 motion for temporary restraining order and preliminary injunction are hereby denied, and that the above styled appeal is hereby closed. Okay. I wanted to read through that just to get everything out there, because the court is kind of like making some statements there to all citizens to try to give their viewpoint of why they ruled the way that they did. And I think it is important to get that the voice of the court out there to you guys so you can hear it. I did want to mention that at the end it says, the above styled appeal is hereby closed. I am not a lawyer, but I'm assuming that I'm interpreting that as to say they're not going to take any more motions in this case, this decision, right? So they're saying it's done, it's over, we've issued our opinion, everything's good. That they are recommending that DeMario or Solomon Simmons, who is representing Grayson Kennedy, or anybody else that's representing Grayson Kennedy, if they're going to challenge the legislative branches on the speed and how this rollout is done for this decision, they need to file new actions, and those actions would probably be, I think, filed in the district court, and then they would go back up to the Supreme Court, just like we followed this case. I'm going to be keeping my eyes open for those actions, and also on the federal level, going through and seeing if anything gets filed there to see, because I'm sure there will probably be more actions filed in this case, barring that, tomorrow the citizenship card the citizenship board starts issuing citizenship cards to freedmen descendants. Then I would expect they wouldn't be filing any motion, but I don't see that in the near future, so I'm going to keep my eyes open for that. We've had some stuff in the chat here. Let me tell you if there's the cases that T.Y. Pearl you're asking about in there. I'm going to need to go look and see what the latest status for that. I did not see anything new in the hunting and fishing thing. The preliminary injunction that you mentioned there, I think it's MCN versus the City of Henrietta. Is that what you're referring to? I didn't see that, but I'll go take a look at it and see if I can locate it. We have been going for about 20 minutes here. I wanted to thank you guys for tuning in. We do have, I believe tomorrow at 5 p.m., I'm going to be doing a live wire with the guys from Decolonized Decatur about a art show they're doing there, and also a green space thing that's happening in Decatur, Georgia, where the space could be tied to the Creek Nation, historically. And then on Monday, I think I had a request from a viewer to do a live stream where we could all get together and talk about the constitutional amendments that are going to be on the ballot on May 30th, which is the special election. So I believe I haven't got a time set for that, but I'm going to try to do that on Monday the 18th. And then also, we might be having a live wire on the 19th about a bicycle tour that Russell Cobb is doing, where he is going to talk about some of the history of the dirty land deals and things that happened along Santa Fe line, I believe. So keep your eyes open for that. That I haven't locked the time down for that. I think the day is good, but I will get you guys more information when it comes to me. And with that being said, I wanted to say thanks for tuning in, and we'll see you again in the future. Mado, hadum, chi hitchot, lees.